This is Apropos. Observers say the case could reshape social media protections for children. Instagram's parent company Meta and Google's YouTube are facing claims that their platforms deliberately addict and cause harm to children. It's the first of several landmark trials taking place this year, as Emerald Maxwell reports.
This is Australia showing enough is enough. And the world is watching and is following.
And he wasn't wrong. Australia banning social media for under 16s at the end of last year set off a domino effect, with a slew of countries considering or passing similar bans to protect children.
Nos enfants lisent moins.
Our children read less, move less, sleep less, and compare themselves more. We should refuse to allow childhood to become a market and our youth to be the playground of algorithms.
Today, our children are exposed to a space they were never meant to navigate alone. A space of addiction, abuse, pornography, manipulation, violence. We will no longer accept that.
Just some of the arguments levelled at social media companies, which also face several landmark trials this year. In Los Angeles, a bellwether lawsuit claims that Meta and YouTube made deliberate design choices to make platforms more addictive to children in order to boost profits, some of which borrow from techniques used by the gambling and cigarette industries. At the core of the case is a 19-year-old identified by the initials KGM, who claims that her use of social media from an early age addicted her to the technology and exacerbated depression and suicidal thoughts. Meta's CEO, Mark Zuckerberg, is expected to testify at the trial, which is being compared to the big tobacco court cases. Those led to a 1998 settlement requiring cigarette companies to pay billions in healthcare costs and restrict marketing targeting minors. The trial is expected to last 6 to 8 weeks. TikTok and Snap, which were originally named in the lawsuit, have settled for undisclosed sums.
To discuss further, let's bring in Frances Haugen, a data scientist, a former whistleblower at Facebook and advocate for social media accountability. Frances, thanks so much for being with us on the programme this evening. Firstly, this particular case that's getting underway as we speak, it's been described as a bellwether proceeding because its outcome, they say, could set the tone for a tidal wave of similar litigation right across the US. Just talk to us a little bit about why exactly it could be so significant.
In the United States, class action lawsuits often fill a gap when issues are so complicated or maybe so contentious that our legislative process doesn't step in at the right moment to pass appropriate safeguards. In the case of social media, we've reached a point where there are 3 major class actions, 2 involving parents and families, one at the federal level in multiple states around the country, one at the state level in Los Angeles, and another involving school districts. These lawsuits will hopefully give more robust rights for children and force these companies to face the consequences of their actions.
And Frances, you actually worked at Facebook as an algorithmic product manager, I believe. In your view, does Meta deliberately harm children or, let's say, do enough to protect them?
So those are very different questions. I think if you asked people who are designing these algorithms, do they set out to harm children? I don't think there's anyone in the company that would say that they willfully, intentionally do that. At the same time, because there is no transparency of what takes place inside these companies, it's very easy to cut corners intentionally or unintentionally and underinvest in the systems that are necessary for children to be safe on these platforms. There's definitely been a pattern behavior for at least 10 years, if not longer, of underinvesting in the basic systems that are necessary for children to safely use these products.
And talk to us a little bit more about the documents that you uncovered, because you're suggesting, I believe, that, you know, from what you've seen and just from your access having worked in the company, you think that Meta chose not to put certain safety mechanisms in place because the thinking was that business would be hurt in the longer term.
It's been a fascinating process over the last couple of years of seeing what has come out as a result of these court cases. Because at the time that I left the company, the documents I brought out only perhaps shed the faintest of an outline saying Facebook knew that the mental health of kids was being impacted by these systems. What has been disclosed already just in the basic court indictment court indictments in the documents that are being released in just the first days of this trial show that Meta ran experiments to change how the product operated. For example, not showing notifications late at night. That they found that the results of those experiments caused children to say things like, I sleep better, I can focus better in school. And yet they chose not to implement those experiments because people use the product just slightly less. We're talking 1% less. That's a classic example of where free operation without any oversight, without any transparency, leads to optimizing for profit over the well-being of kids.
And Frances, we're expecting to hear from your former boss, Mark Zuckerberg, during the course of this trial. What are the tech companies likely to argue here in their defense?
I think likely part of what they're going to repeat, given this is what they usually repeat when they are asked by various of their spokespeople, is they'll say, we have industry-leading protections. But the part that they are ignoring is that in a world where there are very, very minimal safeguards, where the expectation of safety is low, that doesn't mean that you lived up to your duty of care, especially when you're a company like Facebook and you've spent more money lobbying the US government than almost any other single corporation to make sure that those norms, those mandatory floors never come into being. So I'm hoping they'll take responsibility for the consequences that they've brought to a whole generation of children. But most likely they're going to say, we did enough, and hope the jury lets them off.
And what would you say to people who might say that parents have to take some responsibility here as well for perhaps not protecting their children from these apps? We saw lawyers for the plaintiff in this case on Friday seeking to dismiss people as potential jurors who believe that mental health issues were down to parental failure. So is that something that you expect to see being brought up during this trial?
That's been the classic argument against any kind of intervention. They say it's the responsibility of parents to protect their kids. But as someone who has tried to help other parents set up the protections that would allow them to control access to apps like this, it's remarkably difficult to lock down a laptop computer, a tablet, at a level that kids can't get into it. The difference between platforms taking interventions to make sure their products are appropriate for children and relying on parents to have access to, say, technologists that worked on the products in order to make their kids safe are very, very different approaches to safety. We should be living in a world where we like to say you do belts and suspenders. You do defense in depth. The platforms should be taking a stronger stand to make sure their products are safe, and parents should receive the education and support that allows them to use the tools available. All together, that's how we make sure our kids get the experience they deserve.
And it's not just Meta on trial here. Lawyers for Google seem very keen to point out that it is distinct and separate to the likes of Facebook, Instagram. Do you think that YouTube can be held accountable in the same way as those other social media networks?
So I think there are definitely different kinds of ways in which children are vulnerable on YouTube than ways in which they are vulnerable on Instagram. One of the things about social, like software that is meant on a peer-to-peer basis for connection versus one where it's something closer to television, so we're talking about a broadcast system, is that when we're dealing with populations like tweens, so these are young teenagers, they are much, much more vulnerable to feedback and interaction from their own peers. So I think YouTube does have at least somewhat of an argument of saying, you need to design software that has a peer-to-peer social functionality differently than you need to design, say, a piece of broadcast software. At the same time, YouTube also needs to take responsibility for how its algorithms work. For most people, autoplay is on. That means when you watch a video, YouTube can pick the next video for you. We've seen for years complaints around how people can start out on very innocent topics and get pushed through algorithmic escalation towards more and more extreme topics. If you have a child that is mildly insecure about their body and the algorithm pushes them towards pro-eating disorder content, you shouldn't be given a free pass because you didn't think that might be a danger. So I think there is some basis, but we need to hold these companies accountable.
And Frances, we've seen, in recent weeks, particularly governments around the world, from Australia to here in France as well, moving to come out to try and ban younger children from the likes of Facebook, Instagram, TikTok. How much of a threat does that actually pose to the likes of Facebook and Mark Zuckerberg when he's going to be in court over the next few weeks? Is that something that's going to be weighing heavily in the background to all of this?
I think they're profoundly scared of the idea that younger consumers are going to be cut off from access to these products. Because remember, youth culture is in some ways the fuel that ends up keeping these products culturally relevant over time. If you cut off a generation or you push them towards other kinds of technological alternatives, you increase the chance that your product is irrelevant 10, 20 years down the road. So I think that's why they're taking these court cases so seriously.
And this one in California, it's just the first of several cases that are going to be taking place this year. There's a separate case in New Mexico as well, where Meta is being accused of failing to protect children from sexual exploitation. Generally speaking, how difficult is it going to be to actually prove these cases?
New Mexico case, I think, is going to be substantially easier than the cases that are being brought about teen mental health. Because if you go read the indictment on the New Mexico case, they went and made, we'll call them pretend accounts. They pretended to be a mother. They pretended to be the 10-year-old child, 13-year-old child. And they went and I don't say baited men who might be interested in exploiting children, but they behaved in ways that were similar to people who are often targeted by those who look for the vulnerable. And what they found time and time again was that Facebook lacked basic safety protections. For example, if you have a child that says, I'm 10 years old, I'm 10 years old, I'm 10 years old, I'm 13, and you let them in, and that child gets so many followers that you say, maybe you should get a professional account. And those followers aren't even from the United States. Questions should have been asked somewhere along the way. And so I think that case, because of the depth of the evidence, is going to be very, very interesting to watch.
Frances, thanks so much for being with us in the programme. We'll have to leave it there for now. That's Frances Haugen, former whistleblower at Facebook and an advocate for social media accountability. Thanks so much.